I prefer not to utilize affidavits because I'm then locking my client into a set of facts again.
It could be used against them at trial.
And I firmly believe that it's inappropriate for judges to consider affidavits when there's deposition testimony.
Okay.
They do, but that's when your person's been deposed and they've been locked in and it's part of the motion for summary judgment and your only response to it is I'm going to have to create an affidavit that contradicts my own deposition and try to use that as the issue of material fact is I'm contradicting myself, which happens often. That's what the cases say shouldn't be happening. And they talk in the cases about sham affidavits too that happen a lot in the process. But so we get all of the information. We have to look and see what are elements of our defense.
Whatever the tort is.
Right, whatever their claim is, and look through the elements, and you want to list in your concise statement of material facts everything that you would present at the trial to prove that you're right, that's undisputed. And almost every commercial transaction case is going to have a summary judgment motion filed, and every collection case is going to have a motion for summary judgment filed. There are certain types of cases that are always, every employment case, the employer files for summary judgment. Every civil rights case, they file for summary judgment on immunity issues. So there's certain types of cases that, and there are a lot of those types of cases, that are always going to have a summary judgment motion brought.
Right.
And the other part of summary judgment, because it's such a particular area and it's finite, or it can be finite, it doesn't have to, but it can be finite, there's going to be an appeal because it's really something that the judge does make a call. It's not, it's a little bit different than other types of things that a judge does. Many times judges they can be bullies in some respects, and you go down and you're arguing your summary judgment motion, and the judge says, I've reviewed everything and I find there are no genuine issues of material facts, so I'm granting summary judgment. And
well, that doesn't give you a very good record to appeal from.
The attorney has to say, Judge, I want to know specifically what are your findings of fact.
Right.
And the judge says, I've already ruled. And sometimes they.
But there's a court rule on this. So they have to do it.
That doesn't mean they do. And the conclusions of law. But I find, and when they do it on the papers, some of the judges they rule in courts. Now I got to go order the transcript. So I've always asked if they're going to, on a summary judgment, if they're going to rule in the papers, somebody's got to go down to the courthouse when they're going to read it into the record, because you need to know what their findings of fact. But judges very often will do it that way, and I find.
Well, how do you get into the appellate division on something like that, though?
You have to. What I've done is I've filed a motion seeking them to provide their findings of fact and conclusions of law.
Right.